Yes, Mr. Mpofu.
This is, my lord, I think the matter was not called appropriately. It's the matter number CC52/2022P, the matter of Jacob Zuma versus William John Downer, accused number 1, and Karyn Maughan. My lord, I have prepared for your lordship's convenience a form with the appearances. No, don't think so. My learned friends will confirm it's myself, Mpofu, appearing for the public prosecutor. The lordship will know that although these matters are unusual, the private prosecutor,
Yes.
the private prosecutor in this matter is
Mr. Zuma.
former President Zuma, yes. And I'm what you might call the de facto prosecutor, appointed by him. I appear in this matter with Mr. Buthelezi, and for accused number 1, we have Advocate Vim Tengo of SC, and Advocate Hepzibah Raja, instructed by the State Attorney. And for accused number 2 is Advocate Stephen Badlander, SC, and Advocate Janice Blizzard, instructed by the clerk attorneys. I'll address the court briefly on what is likely to happen, but I'll get my learned friends to confirm the appearances first.
Yes, Mr. Van Grove. Yes. Mr. Putlander.
Please the court. My learned friend Ms. Blizzard and I appear from Ms. Maughan.
Yes.
Thank you. My lord, I would just like to praise the court of where we are with the matter, my lord. My lord, let me start by just giving the context. We, as the private prosecution, my lord, are dominus litis, in other words, were seized with the litigation. And it's therefore our duty to put the matter into perspective for the comments of our colleagues and confirmation, of course. My lord, what we have here is something that is unusual, even for us as practitioners. The lordship knows that it is rare that private prosecutions are actually conducted in terms of Section 7 of the Criminal Procedure Act. We will, at the right time, address your lordship maybe in the future about the constitutional foundation of the right of citizens to institute private prosecutions whenever the public prosecution services have declined to prosecute, and that the party aggrieved, as your lordship well knows, is entitled in terms of Section 7 to institute a private prosecution. This particular private prosecution is also unique in that for the first time we have as the private prosecutor the former President Zuma and the 2 accused before us that I've already mentioned. Secondly, my lord, I'd like to just indicate to the court that this matter, in a short space of time, had already produced 4 separate matters.
Yes.
And I'll take your lordship through those. Mercifully, your lordship, is now 3. One of them has fallen away. Actually, it's 2 now. There's this matter, my lord, before your lordship. And then, as your lordship might be aware from the file, I'm not sure if your lordship received or has got the court file. We tried to get the registrar to ensure that your lordship is seized with the
Yes,
entire file.
I only received it on Friday afternoon.
Okay, I understand that, my lord. I'm sorry about that. Yes, my lord, your lordship would have then in front of you, hopefully, the indictment. And your lordship might or might not have, otherwise I'll hand up. Maybe let me just do that just in case, my lord. We have just prepared a duplicate file just in case.
But Mr. Mpofu, doesn't the matter before me relate to the review of the amount that was deposited
Yes, my lord, I'm coming to that. I'm coming to that.
as security for costs?
Yes, yes, I'm coming to that. That's one of the four matters. In fact, that's why I was inquiring whether your lordship has got the file. And I was hoping then, if your lordship can confirm that your lordship will have in front of your lordship the indictment as well as the papers in the application that your lordship is referring
In
to,
the present application?
which is the, yes.
Yes.
My lord, that application was brought by accused number 1, Advocate Downer, for the increment in the security that was lodged. Fortunately, my lord, that matter is one of the matters that I'm saying has fallen away. And again, my learned friend, Mr. Trengov, will confirm. But basically, what has happened, my lord, in that matter, if your lordship would have been in possession of our answering affidavit, yes, where basically what happened was that we made a tender.
You put up a tender for 500,000.
Yes, and on the basis of putting the other side at risk. In other words, if they could not prove more than that amount, then they would pay the costs for that application. My lord, I'm happy to announce that that matter has since been resolved, in that the first accused has accepted the tender, and the parties then exchanged correspondence, which your lordship will find in the new file that we've just. Page 75.
Yes.
Yes, my lord. I won't read the whole letter, but effectively, your lordship will see at paragraph 3 that it says, having taken into consideration the tender made by your client in paragraph 17 of his answering affidavit, in which your tender on his behalf for an additional amount of 500,000 with effect from 3 October 2022, our client has elected to accept the tender. And then, my lord, the rider there is, however, the acceptance of this tender should not be construed as a limitation of our client to seek cost in the ordinary cost at the end of the trial. So that captures, in a nutshell, and then your lordship will see in the next page, 77, our letter where we say we are instructed by our client that he is in agreement with the contents of your letter under reply. So, in other words, my lord, the application for the amount of 1 million rand is therefore no longer in front of your lordship on the basis that I have described. And that matter then falls away subject to confirmation of my learned friend.
So it's, thank you. Yes, Mr. Van Gogh.
Yes, my lord, I confirm that the application for increased security has been settled, as my lord said. I should also mention that my client, Mr. Downer, has launched an application to the High Court set aside as being an abuse of the court. Now, that application has not been characterized as civil or criminal. It's simply a generic application to the High Court, and it would be determined by whoever the judge president deems appropriate. But so we just wish to make it clear that it mustn't be assumed that we intend that application not to be heard before your lordship. In fact, it seems to us that it would be a sensible arrangement for your lordship to determine that application as well. But my learned friend will address you on the program that we have discussed, that we will jointly submit to your lordship. I just want to make it clear from our perspective that we don't regard the application to have the prosecution declared an abuse to be an application which can't be heard before your lordship. That application also makes it plain. Not only do we submit that this prosecution is an abuse and therefore an invalid prosecution, but also that we deny that this court has jurisdiction. One of the complaints is about something they say happened in Johannesburg. And secondly, that we deny that the private prosecutor has standing to prosecute under Section 7 of the Criminal Procedure Act. But those are issues which are also canvassed in this application.
In the other application.
And would therefore be determined if and when that application comes up.
Yes.
Thank you.
Thank you.
Yes, my lord, yes. At least my learned friend has then done what he's supposed to do, which is to confirm that the application for the so-called 1 million rand increment is
settled.
Is out of your lordship. So, yes. Now when it comes to the other applications, my lord, which my
so
lord
can we
which are not before you, I'm sorry.
Shouldn't we make an order in that regard?
Yes, my lord. That's the purpose, of course.
Yes,
well, we're going to
it
continue
is
bringing you
recorded.
coverage from inside the Pietermaritzburg court there, where that trial, the private prosecution, is continuing between former President Jacob Zuma, Advocate Billy Dunn, as well as News 24 journalist Karyn Maughan, who is flanked there by her editor, Adrian Besson. Certainly an interesting case that's caught the attention of many in the country, with a former president taking on an advocate, but also a media practitioner. Let's continue to listen in.
Other applications which are not before your lordship. But for the sake of context, let me slightly with what my learned friend Mr. Trengov has said, because, my lord, those two applications are not so-called hybrid applications. They are applications which have been brought in the civil court, in the motion court. The one was brought in the urgent motion court today, that is in respect of accused number 2, Ms. Maughan. The other one, which was brought by Mr. Trengov's client, was brought, it says for similar relief, but that was brought in due course. And the postulated date was the 8th of December for that one. The Lordship, I don't know if your Lordship has been given the correspondence that was then exchanged with the acting judge president's office.
No.
No, all right. I'll then summarize what happened there.
I'm at the sea because
Yes.
the matter that served before me has now been finalized.
Yes. Well, it's not, my lord, because that matter, remember, was interlocutory to the criminal trial.
Yes,
Yes.
which is not before me. But criminal trial is not before me.
Oh, okay. Well, we understood that the criminal trial was allocated to you.
No.
Why you are
The only file that I
arrested.
had is this one.
Is this one? Okay. Well, in that case, then, my lord, this is what I'm going to say. The other two matters were brought in our respectful submission incorrectly in the motion court. So that they are clearly civil matters. The one matter, and my learned friend Mr. Badlander will confirm, which was the urgent application of Ms. Maughan, has now been removed from that role on the basis that it will go into the ordinary role, and we will seek the directions of the acting judge president for an allocation, my lord. Now, so that was the so-called urgent matter. So that urgency is no longer being asserted. The second matter, my lord, which was brought by accused number 2, also in the civil courts, contrary to what my learned friend has said, under a different case number altogether, 1277022P. Let me just give you a lordship, just for your record. The matter brought by accused number 1, which is Karyn Maughan versus Jacob Zuma, is 12770/22P. Sorry, my lord. The other one. Yes, and the other matter, my lord, is 13062/2. That's the matter for accused number 1.
It's stroke 2 or stroke 22?
Stroke 22, P.
22.
Sorry, my lord. Now, in the correspondence that, I won't bore your lordship with that correspondence, but what we had proposed in that correspondence was that the matters be consolidated at the instance of the accused, which at some stage was rejected, but it has now been agreed that those matters will be heard together at least. And we also had proposed that those matters should follow the timetable set in due course by accused number 1. And therefore, we will be requesting the acting judge president to set those matters down by agreement between the parties in terms of availability on the 8th and 9th of December for hearing. And the reason that we will be making that request, my lord, is twofold. One, it will be, obviously, the parties would then agree, working backwards, the times for exchange of papers and heads of argument and so on. But the reason why we have jointly proposed for the matters to be set for 2 days is because there are also applications by 3 amici curiae, and therefore it might lengthen the hearing. So we just don't want to be caught without sufficient time. Now, what then happens, my lord, is that then the criminal matter, which was set down for today, because that's the matter that was set.
That's the criminal prosecution.
The criminal prosecution itself.
Private prosecution.
The private prosecution. Well, it's a private criminal prosecution. Is by agreement with the parties would then be postponed to the 2nd of February. And that's 2023, my lord.
Yes.
And that obviously we can't dictate to the court, but that is, at least from our point of view, intended to create sufficient time so that there will then hopefully be a judgment in the civil matters.
Yes.
Yes. And again, contrary to what my learned friend, Mr. Trenkov has said, one of the points that we take sharply in those matters, because we've already obviously filed an answering affidavit in the urgent application, is exactly the fact that those matters are being brought in the wrong court, in the civil courts, when they should have been brought here. So that is an issue that will be debated in the motion court, the opposed motion court matters, as to whether that court has jurisdiction to hear interlocutory applications which should be playing themselves here. But I don't want to I can just say in passing, my lord, that when we were when we were on the other side and we've had a similar application, we obviously brought it in the criminal before Justice Kuhn in the criminal prosecution, and that's how it's done. But for some reason, this was brought in another court, but that will be debated there, including the so-called urgent application. But, my lord, in short, then that would be the arrangement. Hopefully, then on the 2nd of February, depending on the outcome in the civil matters, if any, it might be that by then the matter is still in the pipeline. Then we will start with the issues to do with the criminal prosecution. I must just say, my lord, finally, that that timeline will, from our point of view as the private prosecution, will also allow us to deal with all the other formalities, the giving of the docket and so on, and the warning statements for witnesses and that kind of thing. So on the 2nd of February, we will then obviously report back to this court, whether it will be your lordship or somebody else. It will be clear at that time, and then the criminal prosecution will be taken forward from that point on.
Yes, thank you, Mr.
That is therefore the arrangement, my lord. Our understanding is that your lordship, subject to your lordship's direction, of course, is that your lordship should be in a position to confirm those arrangements, because in any event, and I don't know what my learned friends will say, in any event, our understanding is that the application for the increment was interlocutory to the main application, which was the criminal trial. So at least for the purposes of today, your lordship is seized with both of those matters. As court please.
Yes, Mr. Venko.
I'm not clear whether your lordship is seized of the criminal prosecution.
No.
Because if you're not, I'm not sure that we shouldn't be addressing the judge who is seized with that.
Of course, yes. Otherwise than that, you're putting the cart before the horse.
My lord, yes. Well, that's why I started by saying this is, for all of us, even including your lordship, it's not familiar territory. It's not every day that you have these private prosecutions. Let me explain the position, my lord. I don't think there's any complication at all. The position is very clear. We have issued a summons against accused number 1 and accused number 2. On the face of that summons, your lordship will have I took page 1. Actually, page 2, my lord. Page 2 of the summons itself. It's very clear. It says it's addressed to accused number 1, Mr. Downer, accused number 2, Ms. Maughan. To the accused, you are hereby summoned to appear in person before the Pietermaritzburg High Court at 9:30 on the 10th of October 2022 at Court A, which is where we are now, in connection with the charges of which the particulars are mentioned in the indictment attached here to and remain in attendance. So there's no ambiguity, my lord, that the matter set down for today is the matter in respect of which the accused were summoned to appear here this morning, and that's why we're all here. It so happened that in the process, my lord, accused number 1,
decided to bring the application.
Yes, brought an interlocutory application, as he's entitled to do. And that application has fallen away. But that was not our business for being here. Our business for being here was the criminal prosecution and the honoring by the accused of the summons, which is why they are in the dock now. So, in my respectful submission, my lord, any confusion is just superficial. That is the matter, and the interlocutory application has now fallen away. So your lordship is clearly seized with the criminal matter, and I would think particularly because this is all by agreement. Since the arrangement that we seek is by agreement, I cannot see any logical reason why your lordship cannot simply confirm the agreement. If it so happens that the matter, the judge president allocates it to somebody else, well, that's not for us this side of the bridge.
Yes.
That will be something that will happen on your lordship side. So I don't think there's any confusion at all.
Yes, Mr. Van.
I'm not suggesting any confusion at all. All I'm saying is that I want to be sure that I'm addressing the judge designated by the judge president.
To deal with the criminal prosecution. Yes.
I'm happy if it is your lordship.
Well, I'm not aware of that, because it hasn't been allocated to me.
Because if there's uncertainty about your role in the matter, may I suggest that we get clarity about it?
First, before we proceed. We get clarity about that first before we proceed.
Yes, it seems to me that it would be foolish for us to forge ahead.
So you suggest that we stand this matter down, approach the acting JP and find out what's happening
As
to
your
this
lordship
matter.
pleases.
Right. I think it's best we do it that way. Deal with it that way.
Charlie, can I just have my lord, we would endorse that, but with great respect, these things come back to bite one. Could I just correct something that my learned friend has said, because otherwise it's not. My learned friend is correct about the end point. There is agreement between the parties that the two applications, that's Mr. Downer's application to set aside the summons as an abusive process, and Ms. Maughan's application to set aside, that they're not consolidated, they're going to be heard together with
They are
respect.
going to be heard together.
And there's agreement that that should take place.
Sorry, just a moment.
Yes, of course. Thank you, my lord.
Yes.
And there is agreement that we will ask the JP to allocate a judge to hear them on the 8th and 9th of December at the same time.
Yes.
And there is agreement that the criminal matter can then stand until the 2nd of February 2023. That much there is agreement on. There is not agreement that the matter should be heard on the ordinary roll, as my learned friend says. Quite the contrary. It can't be, the ordinary roll hears short matters, the ordinary opposed roll hears short matters, not 2-day special allocations. The agreement is that the matter should be heard by way of an appropriate special allocation to be heard for 2 days on the 8th and 9th of December. And the notion that Ms. Maughan no longer asserts urgency is equally incorrect. Ms. Maughan's position is that the matter is extremely urgent, and she wishes to have it heard as soon as possible, because her case, as appears from the papers, is that the application has been brought for the sole purpose of harassing her, intimidating her, and preventing her from doing her job. Now, of course, Mr. Zuma disputes that, and he's entitled to dispute that, but that is Ms. Maughan's case. But as a practical matter, because the urgent judge couldn't hear the matter this morning because he had a conflict of interest, that is the reason that the matter has not been removed from the roll but stood down. Now, with respect, it doesn't matter because the end point is agreed that the matter should go to an allocation for the 8th and 9th of December. But I do not want to be told, with respect, in 2 months' time in front of some other judge, Mr. Budlander agreed that there was no urgency, there was no prejudice. That is not correct, and that has never been. It's purely as a practical matter that we've agreed to it. And Ms. Maughan will contend in front of that matter that the summons falls to be set aside on 3 grounds. That the matter is an abusive process, a violation of the right to the free media and the right to freedom of expression, that the matter is patently bad because there is no certificate of noli prosequi issued in respect of Ms. Maughan. The only certificate is issued in respect of Mr. Downer, and that Mr. Zuma lacks standing to bring it. So those are, again, matters that will be determined on that day, but I would not want it to in any way be understood that we do not regard the matter as urgent. Quite the opposite. Ms. Maughan wishes it to be heard as a matter of great urgency so that she says she can get on with her job of reporting on Mr. Zuma's trial. Thank you, my Lord.
Yes, thank you, Mr. Pietermaritzburg. Mr. Mpofu?
My Lord, yes, I don't want to detain your Lordship unnecessarily. But yes, let me just put this matter in perspective. If Mr. Badlander is insisting that the matter that will be held on the 8th and 9th of December will still be an urgent application, well, that's his prerogative. As I indicated, that date was specifically chosen because of that was the date selected by accused number 1, Mr. Downer, for a matter to be held in due course. In other words, not an urgent application. But there's no point in quibbling about a matter that's not even before your Lordship here. And for the record, my Lord, all I was saying is that in that matter, at least as far as accused number 2 is concerned, they are in possession of our answering affidavit. And they know that our opposition is based on urgency, if it still is going to be resurrected by the second accused. It's based on jurisdiction, which is the matter that I summarized before your Lordship. We are of the view that that court has no jurisdiction to hear the matter. The matter should have been brought here. It's been wrongly brought in that court. And thirdly, we do not agree that the matter has been brought for the purposes of harassing Ms. Maughan. The matter has been brought for the purposes of enforcing the criminal law because she broke the criminal law by being a participant in the exchange of documents without the permission of the Director of Public Prosecution or the private prosecutor, insofar as those documents concern her. And there are no special rules for special accused. All accused persons in South Africa will be treated in the same way. So they must come and face the music in this court about all those issues, and they are entitled to raise any interlocutory points for delaying purposes or for whatever purposes. But those are matters that will be debated in the civil court. So I apologize for saying that the urgency had gone away. Apparently it's still going to be asserted 3 months later. Now, so that's our position. As far as the proposal of standing the matter down, just to clarify, if your Lordship is seized with the criminal matter, and yes, in respect of which our position has been made clear, we support the proposal to stand down for a few minutes, and maybe we could come to your Lordship in chambers or go to the HAP or in whatever way, but we will find a practical way of resolving that issue. And in my estimation, once that issue is resolved, then we'll just come back for the purposes of confirming the arrangement. As the court pleases, my Lord.
Yes, thank you. This matter will stand down, so I approach the acting judge president in order for him to clarify the issue pertaining to the charge that will be seized to this matter.
As the court pleases.
Court adjourns.